2. Again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to punishment.
Yes, Your Honor. At this stage now that the state has offered evidence as to count as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose. I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this court.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine. All
Okay.
Because it's a prior
All right.
thefts.
right, ma'am, you're Victavia Sanders.
Yes, ma'am.
And Ms. Sanders was previously here in cause number 22-39884. Entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Dr. Feedy, Judge.
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I could address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up. And that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove that, then
Okay, let's go through that.
the necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County. Go to count 1.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track. And I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The
What was-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, ma'am, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard. Cause they be with my mama, and my mama had dementia. And she,
Stop. Stop with everybody else. Because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm
that
not.
if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. Some point you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
this is my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. I know, I almost wish that we had done it just for,
Because they gave her the wrong name and date of birth to the cops. She told them she was a juvenile. She was only 16.
well, and you know what? Now that you did that, I would, maybe I should have, because it might have been worth it. Her last was 8, so I figured. Okay, what are we doing here? This is an MTRP.
Yes, ma'am.
All right, are you Latrick Williams? And will your client waive the formal, oh, never mind. I just remembered what we were doing. All right, so It's cause number 24 DCCR 1791. Mr. Williams was on probation, on a deferred probation. Let me just go back so I can put everything correct on the record, for theft of a firearm, which is, everyone agrees at this point, a state jail felony. And the paperwork for the motion to revoke read a third-degree felony, and we all just went with that. And I revoked Mr. Williams' probation. He was sentenced to TDC, and it has now come to our attention that that was obviously a mistake, and that we need to get him sentenced correctly to the state jail felony. So with that being said, I would entertain a motion for a new trial, even though it is outside the time.
We would move for a new trial at this point, Judge, based on the correct sentence.
Any objection to that?
No objection.
All right, then at this time, I will grant a motion for new trial, even though it is outside the time frame to do that. And so what that means is we're back like nothing happened before that. The case is still pending. You're on the probation, but it's like I did not revoke you. So we're kind of starting over at that point where we were just in October, okay? And it's my understanding that you guys have visited and come up with an agreement with regard to punishment for the state jail felony, correct?
Yes, Your Honor.
And so I think to make the record clean, let's go back through the motion itself, and I'm going to get pleas of true or not true. It looked like before it was 1 through 3 and then 5 and 6, and so I'll just read those that you pled true to already, okay? And so will he waive the formal reading of that motion again? And so let me, I'm just going to print it. It'll be easier for me to, oh, thanks. So in 24 DCCR 1791, I've got a motion to revoke your unadjudicated probation. Shows that you were placed on sorry. Would the state like to make a oral motion to amend the motion to adjudicate?
Yes, Judge.
Okay.
No objection.
To read?
To read that it is a state jail felony.
Okay. No objection to that. Okay. So, again, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 24th, 2024 for the state jail felony offense of theft of a firearm. And that was a 5-year deferred probation. Is that correct? And it alleges in count 1 that you violated your probation by committing the offense of unlawful carrying a weapon May 12th of 2025 in Jefferson County, Texas. Is that true or not true? Count 2 alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County. Is that true or not true? Count 3 alleges that you committed the offense of minor in possession of alcohol May 25th of 2025. Is that true or not true? Count 5 alleges that you committed the offense of resisting arrest or transport May 27th of 2025. And is that true or not true? And then count 6 alleges that you failed to report as directed February 10th and May 15th of 2025. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 5, and 6 freely and voluntarily?
Yes,
And because those counts are actually true.
yes,
I have some documents on the tablet like we had before that you've done today with Ms. Holmes. Did you go over those with her before you signed them?
yes,
You fully understand them.
yes,
And you understand if I follow this agreement, you'll be waiving any right to appeal.
yes,
State tenders number 1.
No objection.
It's admitted any evidence that Mr. Williams is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you another copy of that admonishment regarding your ineligibility to possess a firearm or ammunition. I already read that to you last month. I'm not going to read it again. You understand you cannot possess a firearm because of this conviction in Texas, right? Okay, you can go back with the bailiff. Thank y'all. Again, you're Victavia Sanders,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
You will, Your Honor.
Ms. Sanders, in cause number 25, DCCR 1351, you're charged with the state jail felony offense of theft of property with previous convictions, and that is from July 31st of 2025. The indictment alleges you were previously convicted of theft November 13th of 2017, and then again April 15th of 2019. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have some documents here on the tablet. I guess it's coming. The documents on the tablet that have your signature on them that the state's marked as exhibit number 1. Did you go over those documents with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Why is it less than what I just
Cost of
did?
back time, I think she has less back time in the new case.
All right.
Just so it lines up on the release date.
It's Christmas.
It's Christmas also.
We'll go with that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanders is not competent?
There's none to my knowledge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of theft with prior convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It will run concurrently, which means that they're together at the same time with the other case. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I want to make sure you understand, don't go do this time and get out, keep doing the same things, because it can get worse. Today, what could have happened is the new case could have actually been stacked on top of the other case. I could have given you up to 24 months on one and then stacked the other. So you already know now, we're not playing games. You've got to stop, okay? All right. You go back with the
Your Honor, for the record, as part of the plea bargain, she's waiving appeal on F-22-39884.
Okay.
Waiving the appeal.
Thank you, Mr. Kimler.